Hello and welcome to The Future of Business, the podcast where each week we discuss the issues that will have a significant impact on the future of business in Ireland and beyond, and explore their possible consequences for people in business and for society more generally. I'm Vincent Wall, and today I'm joined by Liam McKenna, partner with Mazars in Ireland, and Eamonn Fitzgerald, Chief Executive of the Hermitage Medical Clinic, to discuss the topic of GDPR, General Data Protection Regulation. Liam, I'll come to you first. What is GDPR in simple terms, and why was it brought in? What's it trying to achieve?
Yeah, so it was brought in for two purposes primarily. The first is there is free movement of people, capital, trade, goods in Europe, and we also want free movement of data. And in order to do that, you have to have some sort of common agreement. And previously there was common EU directives, but they had all been brought into local law very differently. So as a regulation, it trumps the local law, and therefore we can have some level of consistency. So that's the first thing. The second is probably that the last time the Irish data protection law was given a really big change was 1988 and, well, maybe subsequently 2003. And since that time, the world has changed dramatically. In 1988, people weren't using the internet. And in 2003, we didn't have smartphones. So, you know, how the risks and how people are using data has changed so dramatically that it's necessary to bring in place some sort of legislation to control that.
And in practical terms, is this the EU basically saying to large corporates, the pendulum needs to swing back now in terms of the rights of the individual to their privacy, how they manage it, how their private data is collated, how it's stored, and some sort of authority from them as to how it's used?
Yes, very much. And to some extent, you know, everybody is captured by this thing. And you've talked to a lot of smaller organisations who feel a little bit annoyed about it, but you're right. At the large organisation level, they're already doing things that threaten our privacy, and I suppose over time that's probably going to get to medium-sized firms and smaller firms. And at the moment, our digital profile we're talking about, but what about our genetic profile, our biometric profile? What about Tinder based on your biometric profile or your genetic profile? So to some extent, the companies that are caught now, we're trying to drag them back or put control around them. But it's also about putting in place a framework for organisations that are only really getting into this area of risk to be able to build going forward.
Eamonn, I suppose to some degree, most consumers, whatever product or service they're consuming, most consumers really only saw this deadline ticking down through the emails they got from various organisations to say, do you want to still hear from us? Tick the box if so, if not. But from a private hospital's perspective, what were the challenges on the ground in actually complying with GDPR and the implementation deadline that came in May?
Sure. So I suppose the first thing I'd say is that GDPR is, as Liam has said, an incremental harmonisation of data protection regulation across the EU. We did already have pre-existing in this country requirements under data protection legislation to look after with some integrity the information that would come to us by dint of looking at patients as data subjects and sensitive data subjects. So the on-the-ground challenges have been mobilising information and education as much about what GDPR is not about in terms of misconceptions as well as what it is about. And fundamentally, it's executing a core value that we have a responsibility, if in receipt on a lawful basis of patients' data, to make sure that it's accurate, to make sure that it's only used for the purpose for which it's intended to be used, and to make sure that it is stored and transported, whether it's digitally or in hard copy, in a way that protects the integrity of that data and the right for people to be forgotten, and therefore if they no longer want their data held, that we have mechanisms in place to deliver upon that and show evidentially that we've done that.
It's amazing the number of people who know a little bit about GDPR and have decided to demand their right to erasure. Look, I want AIB to forget I have a mortgage. And, people make these sort of requirements, and obviously that's not going to happen. Or the misconception that you need consent to do everything. We get people in, I didn't consent to doing this. Well, we don't need to consent. So I think Eamonn's point around the misconception, and when we're preparing organisations for it is so that their frontline staff feel confident to know, hang on, just because this person's on the end of the phone shouting at me about GDPR, they may not be right, and we want to give them the confidence to know what their lines are.
In that context is one of the key concepts that an organisation has a right to collect and hold data with the authority of the consumer if they have a reasonable business connection with that person.
Yeah, absolutely. You know, there's a confusion that consent is the basis for all lawful processing, but there's 6 lawful bases for processing. There's consent, there's legitimate interest, and that means we're not communists, we are businesses, we have a right to make money, and we balance that with your right to privacy, so that's legitimate interest. There's a contractual basis, there's a requirement to, comply with a different law, anti-money laundering. You need to ask for proof of identification. There's public interest, which isn't available to commercial organisations, and then there's vital interest. If somebody is on the street, collapsed, and you start processing their data to give them healthcare, well, I think they'd be happy to do that. So yeah, there's a number of reasons, and consent is only one.
How important was it for you, and how challenging was it for you, Eamonn, to engage your staff on, I suppose, just the lifting of the bar in terms of the compliance areas now? I mean, your staff, I presume, are your front line in terms of this area.
Absolutely. So we are a member of the Private Hospitals Association, 17 other private hospitals, all of whom are accredited internationally, the majority by Joint Commission International, others by the Mental Health Commission in Ireland if they're involved in psychiatric care, or other forms of internationally accredited organisations. And we have as a core commitment in terms of the ethos of our organisations, the delivery of competent, compassionate care to patients and, by extension, their families. And it's interesting that one of the international patient safety goals, of which there are 6 within the Joint Commission International framework, is effective communication and appropriate identification of patients. So it puts at the top of international patient safety goals the absolute imperative of appropriate communication. And GDPR is about appropriate communication, in essence, that you only have what you need to have in order to appropriately or optimally care for a patient, and you only use it with their consent for the intent for which it was required to be used. But to Liam's point, you have people who have a rainbow coalition of views as to what that means, as opposed to one global interpretation of the legislation, which is challenging, I think, in fairness, for people to get to a common denomination of colloquial understanding, the man in the street understanding of it. And it's that practical approach that we instill and imbue in our staff. Be empathic. What would you expect if it was your mother or father or cousin or grandparent, or indeed you yourself? And it is about only having what's required to be in our possession in a safe, secure way under information governance. We live in a ubiquitous technological world now in terms of the internet and mobility of information, and that's fantastic in terms of opportunities, but it also brings risks. And inherent in that risk, as we've seen in the NHS, is cyber attack, where systems are harvested and exploited so that data can be extracted and then sold on. So data has a value now that it didn't have, or wasn't a recognised value in the past, and is capable of being exploited. So it's critically important that patient records do not fall into the hands of people that they were never intended to be possessors of.
Although no organisation can be absolutely guaranteed that won't happen, given the skills and time that the cyber thieves now spend.
Absolutely. And inherent in delivering optimal patient care is having the biographic and demographic data. It's about how you control that within an environment that recognises that there's inherent risk in order to deliver benefit. And I use the analogy or metaphor of radiation or drugs or other forms of therapies for people. If they're used on the basis of good control and good governance and on an informed and consented basis, they are likely to have the desired effect, which is a benefit. But there's inherent risk with that, whereas with data, if it's used for the purpose for which it was intended, it contributes to the efficacy of care.
Yeah, and just on the point around everybody has risk, right? You can't guarantee that a breach won't occur. You can't, but the GDPR is very clear that if there's 18 hospitals in the Private Hospitals Association and 2 of them suffer the exact same breach, it will be taken into context. What have they done? And if one has done an awful lot to try and protect the data and use it correctly and has been unlucky, and another has been casual about it, the second will be much more severely dealt with. And we're talking fines up to 20 million, 4% of global revenue, plus on top of that then civil actions where people can come together and sue you, which may well end up more. So, although there's difference, you can't guarantee it. You can certainly mitigate your risk significantly.
And other than that ever-present and I suppose growing threat of cybercrime, what are the key risks, do you think, for businesses generally, large and small, Liam, as the new regime, I suppose, begins to take root?
Yeah, so we need to deliver the rights of the individual. So typically what you see complaints about to the Data Protection Commissioner are, I've asked for my data and they haven't given it to me, or they don't have a lawful basis to process the data. They're since May now, they're probably the 2 of the most common complaints that the Commissioner has received, and complaints are up from previous times. So, being able to identify where data is about individuals and then gather it together and then make a decision. Do we have to give them all of this? Because there are situations where you don't necessarily, you don't want to give them. In HR situations, there are times where there are conversations that go on which are private between individuals and might mention somebody.
Because, of course, employees are every much as bit a stakeholder here as consumers.
Yeah, so there's a lot of effort goes into understanding what can we redact, what do we need to provide, but probably the delivering on those rights of the individual, erasure, rectification, subject access requests, they're where most of the focus has been for the Commissioner.
And that's where most businesses should focus now, if they haven't already.
Yes, well, certainly the security piece, like your most likely way you're going to lose money on the back of GDPR is a big fine because you haven't got the right security in place. But what you can do from this other perspective is definitely focus on those areas, and transparency. Having a privacy notice that is very clear and says, look, this is what we do with your data. This is the reasons we do it. This is how we justify it. And this is what you can do in order to invoke your rights.
And just building on that point of Liam's in terms of security, it's more probable that organisations will have the appropriate policies, protocols and procedures. What's most likely to be the Achilles heel is the information systems and security. And ISO 27001 is an internationally recognised standard and framework which organisations might espouse to achieve in order to ensure that the security of the data is optimised, and you identify risk, you analyse risk, and you control and mitigate risk, as opposed to being able to transfer it. You just, in the world we live in, you can't transfer the risk of requiring data because every organisation needs it, not least of all in healthcare. And that's all of healthcare, public and or private, because the patients really expect the same standard of care, and we have an obligation, no matter whether the state owns the infrastructure or independent capital owns it, to deliver on a duty and a standard of care that recognises and respects that for all consumers of it.
You use the term we there, but you and other members of the Private Hospitals Association, you have direct employees, obviously, but you also have medical consultants who are contracted to you, but who are independent practitioners in their own right. Does that complicate the environment for you in terms of making sure that patient data is properly managed?
I wouldn't necessarily frame it as a complication. It's certainly an aspect of the importance of commitment as opposed to edict and control. People need to have a value base where whether it's the patient going on the initial part of their journey to their general practitioner, and then their general practitioner communicating a referral to the consultants, who in turn communicate to the hospital as to what needs in order for the care to be delivered. Each of those points of communication have potential points of failure, and we work together in a very collaborative way, because the consultants obviously are primary patient advocates, and they are there to protect patients, not in a paternalistic or a patronising way, by providing advocacy, not alone in terms of their clinical expertise, but also in terms of making sure that the patient data, the medical information, is kept only on the basis of how it should be. So I don't see it, as I say, necessarily as a complication, but it certainly requires consideration, and it requires an enhancement of communication understanding as to what is the plot here? What are we trying to achieve? What's the call to action? And the call to action is, in order to care for patients, we have to have a certain amount of data. And in order to respect their rights, we have to treat that data or information in a particular way. And now we're being assisted with absolute crystal clear clarity through this harmonisation mechanism to achieve that.
But one of the areas where it is left to the organisation itself to determine, or to try to determine, is the amount of time that data is stored on behalf of a consumer, in your case patients, and that must be a difficult issue for hospitals, because that data may be useful to a family member even after the death of a patient.
Absolutely, but there isn't a prescription in the regulations as to how long or not you can hold the data. It's more around, do you have a legal and fair basis in which to hold the data? So you have issues with children who, until they become adults, can't make decisions in their own right. And therefore, if you were to make a decision to not hold their data until they came to an age where they can decide for themselves, you would be taking away an opportunity. Now, you would absolutely want their guardians, whether they're their parents or other guardians, to assist in the protection of that. But in terms of, yes, people with chronic conditions, if you're going to have seamlessness around the care of people with chronic conditions, if you take meaningful data out and destroy it, you have not done them a service. But that's not to say that you can continue to hold data for unlimited periods of time. So you need to have a thought-out policy as to what's a reasonable retention period for data. And that can be challenged, and that's fine, and people can exercise their right, notwithstanding what's deemed to be in their benefit, to have a different view and act on that different view.
Yeah, it's interesting because the Commissioner did a report on hospitals last year, and specifically said that they wanted to see, the Data Protection Commissioner wanted to see retention periods invoked. But, you know, if you do a pinprick test on the heel of a child the day it's born, there are medical professionals who would say, well, we don't know how the technology will improve and how that might not be important when the person is 70. So, you know, in the medical environment where you have a balance between potential safety of the patient or physical benefit to the patient versus GDPR compliance, it's a difficult balance, and retention is a problem across all industries, but it is hard in this area.
Eamonn, have you had an upsurge of consumer interaction given the implementation date last May, given, I suppose, the profile given to the whole issue? Have you had more people kind of contacting you about this?
No, not an upsurge. And that's because I think people are sensitised to the fact that when they're giving informed consent, part of the informed consent process is to explain to them what's being done, why it's being done, what the risk, benefits and alternatives of doing it are by somebody who's competent to deliver the care. And in that very structured conversation, they are brought on a journey of participation in their care, where they know that if at any stage they want more information or want all of their medical records, that they're absolutely entitled to it. So we're very clear that while we hold the information, we don't own it, that it's theirs, and therefore we're the guardians or custodians of it. So it hasn't been such, in our experience, that patients are now asking, you know, by way of a surge, are we getting some different questions? Absolutely. But again, I think it's reflective of understanding or misunderstanding that's in the system. And it was always GDPR predated by pretty robust data protection legislation in any event.
Yeah, and actually, it's interesting because we deal with a number of clinics in Mazars, and the people who are responding to these subject access requests are actually surprised that people think they need data protection law in order to get their data. Like, clinics generally would say, if you want your medical records, of course you can have your medical records. You don't need to come to us with this. So it's a process that actually happens more quickly than would be required under GDPR. They just do it.
We talked at the top, Liam, about why this has been brought in. Is it going to be effective? Ultimately, it's going to be down to the data protection agencies in each member state to police this. Are they going to have the time and resources to proactively police it? Or is it likely that there's going to be a big case somewhere because of a security breach or something?
Yeah, so, we don't know yet how it's going to be policed. What we do know is that it will be the commissioners across Europe are peers of each other and expect the same level of fines and sanctions, administrative actions. So Ireland will be brought to the same level as Germany and the Dutch, various other countries which are seen to be at a very high level. I think it has made a difference already. In late August, I remember reading a story that the Students' Union had stopped releasing leap cards to their students because they challenged the National Transport Agency database and how much access they had to it, and they were concerned about GDPR. I have no idea if there was anything in it or not, but just the point that organisation would go to another organisation and say, we're doing something here, and is this right in GDPR? That would never have happened.
So at the very least, awareness has been raised.
Absolutely. And, the risks are going to increase dramatically with how we use data. We're only at the birth of big data.
I was just going to wrap it up by a question to both of you that basically this is the start. That will you expect, I suppose, the level of detail, the level of compliance requirement to evolve over time, to become more stringent? I suppose as technology changes and we just, as organisations, get more and more information about people. Liam?
Yes, absolutely. And there's more legislation to come. And I suppose we'll see how fines pan out, and there's a lot more clarity required in certain areas of it. So yes, absolutely.
Yes, absolutely also. And I think it's very clear that technology is becoming more and more ubiquitous in health and social care and in society in general. So as more and more of this data is available, and an example was given in terms of people using Fitbits, and if that information was available to their employer, and would that or could that be linked to people's record of attendance? So an unintended consequence of...
Or sold on to an insurance company,
or whatever, an unintended consequence of capturing data would be that it would ever get used by a third party for a purpose for which it wasn't intended. But we are in a situation where the Internet of Things is going to, if not revolutionise, evolutionise what and how we're capturing data and making it very portable. And while there are great upsides to that, I think there's also going to be a requirement for continuing protection for people who may not have thought through the unintended consequences of the benefits.
Yeah, and I suppose I'd just say, to remind people that we're all data subjects, and our children and our parents are data subjects. And, this framework is there to protect us. If you look across the water in the States, a big telco in the States could sell every single piece of your browsing history, and they could gather it from all your devices across your house, sell it to somebody without telling you, and they would know everything about you. You can't do that in Europe because of GDPR.
I think it's very interesting that the Ministers recently published a statutory instrument in terms of health research regulation to make sure that research is not thwarted in healthcare but accommodated and enhanced, however, making sure there's appropriate governance around data and information that is a requirement in order for research to flourish.
I think the principal points that I've taken from this conversation is that the directive has been brought in to protect us all, to swing the pendulum back in favour of the consumer against, I suppose, those large organisations that might have been seeing, whether deliberately or not, to exploit that unnecessarily. That for most organisations, and it's interesting to hear it from the frontline healthcare sector, for most organisations, it's a continuation of best practice that was already there, but to engage your staff on how would you treat your patient as if they were your own relative, not just in terms of the healthcare you give them, but how you manage, store and use their very private data. And I suppose that this is only the start, and it's going to evolve and change as in technology changes, as technology engages with more and more of our lives. Thank you to Liam McKenna, partner with Mazars in Ireland, and Eamonn Fitzgerald, Chief Executive of the Hermitage Medical Clinic and a member of the Private Hospitals Association. Thank you for listening to The Future of Business with Vincent Wall and Mazars. We welcome any feedback to our podcasts and particularly your suggestions as to topics we should cover. You can comment and rate us wherever you find this podcast or on mazars.ie. Bye for now.